Welcome to Tecnia TV. Hello everyone, I Jyotsana, Faculty of MBA Department from Tecnia Institute of Advanced Studies. Today, I am going to deliver a lecture on the topic Unpaid Seller. First of all, what are the rights of unpaid sellers against goods? An unpaid seller has certain rights against the goods and the buyer. In this lecture, we will refer to the sections of Sales of Goods Act 1930 and look at the rights of an unpaid seller against goods, namely right of lien, rights of stoppage in transit, etc. Right of lien, seller's liens, section 47. According to subsection 1 of section 47 of the Sales of Goods Act 1930, an unpaid seller who is in the possession of the goods can retain their possession until payment. This is possible in the following cases. Number 1, he sells the goods without any stipulation for credit. Number 2, the goods are sold on credit but the credit term has been expired. Number 3, the buyer becomes insolvent. Subsection 2 specify that the unpaid seller can exercise his rights of lien notwithstanding that he is in the possession of the goods, acting as an agent or bailey for the buyer. Part delivery, section 48. Further subsection 48 states that if an unpaid seller makes part delivery of the goods, that he may exercise his rights of lien on the remainder. This is valid unless there is an agreement between the buyer and the seller for waiving the lien under part delivery. Next, termination of lien, section 49. According to subsection 1 of the section 49 of the Sales of Goods Act 1930, an unpaid seller loses his liens. Number 1, if he delivered the goods to the carrier or the other bailey for transmission to the buyer without reserving the right of disposal of the goods. Number 2, when the buyer or his agent obtain possession of the goods lawfully. Number 3, by waiver. Further subsection 2 states that an unpaid seller who has a lien does not lose his liens by reason only that he has obtained a decree for the price of the goods. Right of stoppage in transit. This right is an extension to the right of lien. The right of stoppage in transit means that an unpaid seller has the right to stop the goods until they are in the transit, regain the possessions, and retain them until he receives the full price. If an unpaid seller has parted his possession of the goods and the buyer becomes insolvent, then the seller can ask the carrier to return the goods back. This is subject to the provision of the Act. Next, duration of transit, section 51. Goods are in the course of transit from the time the seller delivers them to a carrier or a bailey for transmission to the buyer until the buyer or his agent takes delivery of the goods. Next, how stoppage is affected, section 52. There are two ways of stopping the transaction in goods. Number 1, the seller takes actual possessions of the goods. Number 2, if the goods are in the possession of the carrier or other bailey, then the seller gives a notice to stoppage of that good. On receiving that notice, the carrier or the bailey must redeliver the goods to the seller and the sellers can bear the expenses of the redelivery. Next, effect of stoppage. Even if the unpaid seller exercises his right of stoppage in transit, the contract stays valid. The buyer can ask for the delivery of the goods after making the payment. Next, the main difference between the right of lien versus the right of stoppage in transit. Number 1, essence. In the right of lien, he retained the possession. In the right of stoppage in transit, he regained the possession. Number 2, who has the possession of the goods? Obviously, the seller. And the next, the carrier or the bailey. The buyer should not have received the goods. Number 3, main point, buyer insolvent. Not at all a compulsory requirement. Next, the right can be exercised only when the buyer becomes insolvent. In simple words, we can say that the right of stoppage in transit begins when the right of liens end. Next, the pledge by the buyer, section 53. Unless the seller agreed the right of lien of stoppage is unaffected by the buyer selling or pleading the goods, the principle is very simple. The second buyer cannot be in a better position than the seller, that is the first buyer. However, if the buyer transfers the document of title or pledges the goods to a sub-buyer in good faith and for the consideration, then the right of stoppage is defected. There are two expectations to make note of it. Number one, the seller agreed to resale, mortgage, or other disposition of the goods. If the seller agreed to the buyer selling, pledging, or disposing of the goods in any of the other way, then he loses his rights to lien. Number two, transfer of the document of title of goods by the buyer. When the seller transfer the document of title of goods to the buyer and the buyer further transfer it to another buyer who purchased the goods in good faith and for a price, then number A, if the last mentioned transfer is by the way of sale, the original seller right of lien and the stoppage is defected. Number two, if the last mentioned transfer is by the way of pledge, the original seller right of the lien or the stoppage can be executed subject to the rights of the pledge. Right of resale, section 54. The right of resale is a very important right for an unpaid seller. If he does not have this right, then the right of lien and the stoppage won't make sense. An unpaid seller can exercise his right of resale under the following conditions. Number one, goods are imperishable in nature. In such a case, the seller does not have to inform the buyer of his intention of resale. Number two, seller give a notice to the buyer of his intention of resale. The buyer needs to pay the price of the goods and ask for the delivery within the time mentioned in this notice. If he failed to do so, then the seller can resell the goods. If he also recovered the difference between the contract price and the resale price, and if the latter is lower. However, if the resale price is lower, then the seller keeps the profit. Number third, unpaid seller resells the goods post exercise his rights of lien or stoppage. The subsequent buyers acquire a good title to the goods, even if the seller has not given a notice of resale to the original buyer. Fourth point, resale where the right of resale is reserved in the contract of sale. If the contract of sale specifies that the seller can resell the goods, if the buyer defaults, then the seller reserves his right of sale. He can claim the damages from the original buyer, even if he does not give a notice of resale to him. Property in the goods has not passed to the buyer. The unpaid seller can exercise his rights of withholding delivery of good. This is similar to the right of lien and is a quasi-lien. So I hope you understand this lecture. Thank you for watching this lecture. If you like, please like and subscribe Tecnia TV.